You're listening to the Valley Current.
Let me come at the problem a different way. It seems to me that if we all agree that the common law would have had an equitable estoppel defense here available, and you don't contest that. The question is whether this court should create something more on the basis of Formica and Scott paper, which I understand the criticisms of. But the SG says we can save the day, we can fix it. And it's going to be more than equitable estoppel, but it isn't going to be that much more. Arm's length, valuable consideration materially.
I was just playing a few seconds of Gorsuch, and that we're talking about this doctrine that I think I've always wondered after Lear versus Atkins, when they would finally get, having decided licensee estoppel didn't apply, when they would get to the assignor estoppel. And it took them seems like 30 plus years.
More like 70.
More?
Yeah, since like 1924, right?
Lear versus Atkins was what year? I thought Lear and Scott Paper.
Oh, that was Scott Paper was in like the 40s. But Scott Paper was didn't actually answer the question at all. I thought it was interesting that counsel opened with Scott Paper, which I think is completely not apposite, as they like to say.
Right.
So, and Lear, I think, is not even that apposite. I mean, it's like, so somebody who buys it can challenge. That is different than the kind of thing that you would bar people from doing when they sell it. It's like a completely different thing.
Yeah, let's set the stage. Lear versus Atkins was a 1969 case, 395 U.S. 653. I remember thinking this was one of the first cases that I read in the area of IP in law school. And it's in this area where patent law trumps effectively contract law, because if you put a recital in a contract that a licensee hereby agrees that the patent is valid, most people would think, well, that's a matter of contract, right? And the Supreme Court came in and said, no, patent law has a strong federal policy to cause invalid patents to be challenged, including by licensees that may have deep knowledge. And that case really did change licensing from that point forward in a big way.
Right.
It still has a point. But in law school, I always wondered, well, at what point will they get to the sort of corollary, which is, well, what about someone who assigns a patent and declares in the assignment that the patent is valid and that they're not going to challenge the patent? The same federal policy of seeking to invalidate bad patents apply as well to the inventor. And it took them a long time to get there, if you ask me. I mean, it took them like 60 years plus. If we're talking 1969, right? 50 years. 50 years plus, right? And it's interesting because I thought the most persuasive parts of the oral argument, I was just playing some of it, and just so the folks know, you can get this stuff online now on C-SPAN. C-SPAN essentially gives you a full range of tools to listen to the oral argument. And they also publish these oral arguments because they've been doing them by phone in real time. So you can listen to them literally as they're occurring. If you have the time to do it, then they're recorded and you can listen to them. And the case we're talking about today is this Minverva Surgical case. And what's your general reaction to the quality of the argument and generally what you heard? And then we'll talk about making predictions from all this.
I thought the argument was good. I feel like the court, doesn't know what to do, right? I mean, they ask good questions of both sides. It's hard to count votes on this one, but, it feels like the court is like, well, you can't just get rid of it, right? I mean, they just upheld Lear v. Adkins on stare decisis, so why wouldn't you uphold this on stare decisis? But at the same time, there are lots of times when it shouldn't apply. So what are we supposed to do?
Right. It seems like they want to carve out some view that it really depends on specific facts associated with whether or not equitable estoppel, which they did get the petitioning party to recognize still will exist, and presumably under 50 different varieties of state law, because we're dealing with state law, not federal law, in dealing with the questions of contractual estoppel or equitable estoppel, right? I mean, it's not like a body of federal law per se. It's a body of what state did the transaction occur in, like the sale of the patent.
Right. Well, it's like, it's like this federal common law, right?
But is it? But is it even federal common law, or would it?
I think
vary
it is.
Based on California, New York. You think it is actually federal common law?
Yeah, I think it is, in the same way that license, that they can bar licensor estoppel. I think it's patent policy common law, right? There's this penumbra around the statute that's really common law, and so this is part of it. So I don't think this is like employer assignment of inventions kind of thing, right? And it comes with that, the way that is state law based.
You would draw a distinction there and say that the employer can stop the employee that has contractually and or work for hire type agreed to assign?
No, I'm just saying that whether an employee has assigned an invention is a matter of state law, right? Like people hired to invent, people who sign assignment agreements, whether or not the employer owns the invention or has a shop right is a matter of state law. So, but I think this is different than that once it's been assigned.
Well, let's break out the cases, because I think we want our listeners to think about this, because this is classic law school argument. To me, this oral argument was almost like a law school class to me, very similar to a law school class. And we're talking about Minverva Surgical versus HoloLogic. And these arguments are all available on C-SPAN and a few other places. And the remark I will make is you can think of at least 3 different cases, and I think you've identified them. One is the employer-employee relationship where state law, particularly in places like California, but New York too, and other big states, is trying to design some careful balance between what the employee owns or pre-existingly owns and what the employer owns once the employee starts working and is hired to invent and perhaps is creating, for example, computer software as a work for hire, which the employer is going to own their copyright principles, going to own presumably under trade secret principles, which is typically state law, although now we have a federal Trade Secret Act as well, and is going to own the patent rights, typically by dint of a written agreement that will also say, look, you're going to do everything that we ask you to do, include sign things under oath about this invention that we want to protect for the company, right? So that's one area where you seem to concede, yes, state law is going to control that relationship. And what happens if that employee leaves and then challenges the patent, whether or not there would be, absent this case, some type of estoppel. Because this federal circuit, I guess the case there was what, Westinghouse? There was some case in the federal circuit that has existed as sort of a statement that assignor estoppel is different than licensee estoppel, right?
Right, which it is.
Right.
So,
well, you see it as different because you think that there's an oath involved, and the oath itself lends itself to tell the truth and the whole truth. And once you sign it,
no, it's not that. It's not that. It's that if you sell your patent to somebody, you do so with an implicit promise that you're not going to then try and kill the patent.
Oh, there's some covenant of
that's different than when you buy something from somebody. You don't make an implicit promise that you're not going to try and destroy it.
Oh, okay. So you're saying in the licensor-licensee case, the licensee is sort of beholden to the licensor and is saying, you know, you're representing what it is. I have to take that as a given, but I'm not necessarily bound. It seems a different set of equities to say that I'm bound.
Now, that said, by the way, I think the licensee estoppel is wrong, but not because it's the same as assignor estoppel. I think it's wrong because when you promise to license something, you're taking away the case or controversy, and it's unfair to be able to sue somebody who can't sue you back. So
you're saying the licensee gets the benefit of the bargain and also the benefit of the challenge? Right.
So I wrote an article about this many years ago called Patent Challenges and Royalty Inflation that talked about the fact that the one-way challenge right actually increases royalties. It creates a upward spiral. But whatever my thoughts about that, it is a different problem than the assignor estoppel, which is basically when you sell something to somebody, it comes with an implicit promise, not at the state level, but at the patent level, that you're not going to then challenge the validity of the patent. Well, that's why I thought the citation to Scott Paper was so not relevant, because Scott Paper was basically saying, when you do that, that doesn't mean you have to roll over when they sue you for infringement. You're allowed to say, I'm not infringing because I'm practicing the prior art. That's what Scott Paper said.
Okay.
So that's different from assignor estoppel, which is the implicit promise of saying, I'm not going to sue you.
Right.
So now the question is I'm sorry, I cut you off. Go on.
Okay. But in both cases, you've got this public policy that says we want invalid patents to be thrown out of the system. And we want people to challenge patents that are worthy of challenge, right? I mean, that's the conflict. The conflict is you can
that's true.
You can have a contract, or you can have a oath-based, or you can have a good faith and fair dealing-based type estoppel, but you still have this body of policy, federal policy, that says patents that are not deserving of being valid because prior art or other reasons, they should be kicked out of the system. They should not clog the system. They shouldn't be up there, right?
That's correct. So the question is, you may say that we will override this implicit promise that we've had for years and years and years, because we think it's so important to be able to get rid of patents that are bad. You may say that, but that's still a different thing. Then you're just discarding assignor estoppel, but that still makes it a different issue than licensee estoppel. What you're saying is the things that animate licensee estoppel cause us to not have assignor estoppel.
Okay.
And that you're saying that they animate us not having licensee estoppel either, although it's two different things. So I guess what you're saying is, well, is this rule that you must get rid of all bad patents so important that it gets rid of all licensee challenges? The answer is yes. And then would you extend that? It must get rid of all assignor challenges.
Right.
My view is, there aren't that many assigners of a patent. There's only one inventor who signs it, right? Or anybody else down the line. Whereas there can be lots and lots of licensees who are forced to the dynamics are different. When you're an assigner, you're doing it to make money because you are selling your patent to somebody. Whereas when you're a licensee, you have to pay money because the patent is being foisted on you. So goes the argument. I'm not saying that's how it works. But if that's the argument, then we worry about licensees in a way we don't worry about assigners. But that also leads to what are the limitations, right? If the assignment is so limited, right? If it was a founder who happens to be an employee of a company that now is being challenged, is that enough to be assignor estoppel? Maybe that's too far.
Well, the part that you said a minute ago about, well, it's just one assignor, it can be 3 or 4 co-inventors, and they're
sure.
three or 4. And I wonder what happens in these weird cases where, just one of the assignors, breaks out and says, I'm challenging the validity of this, and the other 3 go the other way. I guess you just have a contested case involving who can produce what evidence of either suppressed prior art or inequitable conduct in the patent office, or a host of other factors that maybe only the inventors know, right? Because that's part of the problem here. The inventors often know a lot of what went into making the sausage that the assignee wants to sort of negotiate some degree of confidentiality around. And you might say, well, that's the exact case where you want to allow some whistleblowing if there is some internal knowledge of some sort of inequitable conduct that should become or should invalidate the patent and maybe the entire family of patents. I mean, there's so many different cases where you wonder whether a set of facts will give rise to a set of equities going one way or another. I get your drift to your point that, well, a host of licensees, they're being sort of pushed. And if there's a situation where they want to challenge, they should be allowed to challenge and then presumably renegotiate their deal or suffer as a result, right?
Right. But you raise a good point, which is, right, one of the things behind licensee estoppel is the licensees are in the best position to challenge. They've got the most motivation. And so assigners, you're saying, maybe in the best position to know the prior art. But that's precisely why I would argue that you can't allow them to do it, because it's like attorney-client privilege in that sense. You can't have people selling the patent and then going right after it. It's like biting the hand that feeds you.
Well, it's what gives rise to principles that accept out of the body of antitrust law, where California has a rule that you can only have a non-compete under 16600
right.
of Business and Professions Code if you're selling a business.
Right. You can't sell it and then challenge it. That's
right. You can't sell the business and then turn around and say, oh, those assets were all in the public domain because you were just paid. So there is a set of equities that is sort of well ingrained in the law. And it seemed as though Justice Sotomayor in particular said, well, look, we have this doctrine of stare decisis that has recognized for a long time, and then compound that with, in 2011, the American Invents Act was legislated into being, and they didn't touch this. They could have presumably written something into the revised Patent Act to deal with assignor estoppel, and they didn't. So she was pretty persuasive in my book in asking questions about, now I don't know if that means there's a split and we're going to see a 5-4 decision or a 6-3 decision or some other split here, or what?
I don't know. I think it'll really be the breakdown, right? Because there are times when you can see it shouldn't apply. What if it's the blanket employee?
Right.
The blanket employee assignment. What if it is like an employee of a company, not the founder? Where it's more attenuated, right? So there's got to be some limit to it. I can see the court punting. I can see them saying, well, it exists, but not in this case because it's a founder of a company, although that to me is pretty dicey. it exists in this case, but there may be other cases, and we leave it to the lower courts to flesh it out, and maybe we'll hear another case in the future on it. I think that could happen, right? That's what they did with prosecution history estoppel and on sale bar and other things, where they basically leave it to the lower courts to figure out, they say it's not absolute. You guys figure out where the absoluteness ends. And then the courts do, once they get a little bit of guidance, that there's a middle ground. I think you could have middle grounds here that courts could easily work out.
Well, let's put this on. If you can listen to this for a second, and then I'll ask you a question. Let's just listen to 2 minutes from the argument. We're about 20 minutes into the argument by the petitioner.
There's state law remedies, and she can be...
Mr. Huckman, I just want to know if it's a stopped or not.
Sure, it can be a stop.
Okay, now let me ask you about another question, Mr. Huckman. So is there a meaningful difference between that case and a case where the inventor invents something, she swears an oath, she transfers the application before she receives a patent, and the final patent is exactly the same as the application?
Yes, I think there is, because, in that situation, if she knew at the time she swore the oath that she breached her duty of candor, then I think you could have an estoppel. But there are all sorts of things that you can learn. But Justice Gorsuch?
So I'm stopping there. Were you able to hear the last remark by Sotomayor?
Yes. The very, very last remark?
Yeah, the one where she's pressing him to say, well, what if the assignor and the inventor effectively, transfers the patent, and then it issues exactly as the application was submitted, and then She turns around and because obviously if the patent office changes the deal, I guess it's an open game.
Well, that's the potential limiting, but we all know that the patent is never as limited to the exact claims, right? But if there's no continuation, every claim must be supported by the written description of what's in that patent application. And so if the claim is supported, described and enabled, then it doesn't matter if a claim was added, you claim to have invented the thing.
Right. But what I think Sotomayor is getting at is, hey, look, she ends up transferring this and presumably getting some money for it or some other consideration, and then turns around and challenges it. And the litigant, the advocate, Hochner, I guess is his name, ends up saying, well, that's fraud. There's a violation of the duty of candor. And you might say, is it just labels that you're putting on things? And is it sort of like, well, if the conduct is so egregious, you put some other tort label on it and all of a sudden you can bar the inventor? Because if the policy is the inventor gets to challenge because we want bad patents challenged, you don't really care about how it plays out. It's essentially privileged conduct to challenge the patent. Anyway, that's to me is what they're grappling with, this question of where does this federal policy act as a super trumping card that comes in to sort of trump whatever distastefulness we feel about what the inventor is doing. So let's play for a second.
Before you play it though, I do want to say, I'm not sure I fully agree. I don't buy into the oath argument, right? I buy into the you got paid and you shouldn't do it, but I don't buy into the oath argument because the inventor doesn't really know what they invented, right? I wrote this in a very early paper called The Failure of Public Notice in Patent Prosecution. The inventor only knows what they think they invented. And what they actually invented is defined by what the prior art happens to be, both during prosecution and afterward. And so to say you can't challenge because of the oath you made, to me, just doesn't make sense, because the oath is, I believe at this time, based on the prior art I know, which we know people aren't searching for, this is what's valid. And that just can't be the reason why we say, why we hold something valid and you can't challenge it. It's got to be more to the to the estoppel aspect, right? What is estoppel? Estoppel is behaving in a way that is inconsistent with the way you believe the world should be. And so when we call it assignor estoppel, it's by giving this to you, I'm behaving in a way that this should be valid because you are giving me value for it. And it has nothing to do with what the oath is. So I just want to clarify that. That's my view on it.
Okay.
But let's listen to the next clip.
Let me come at the problem a different way. It seems to me that if we all agree that the common law would have had an equitable estoppel defense here available, and you don't contest that. The question is whether this court should create something more on the basis of Formica and Scott paper, which I understand the criticisms of. But the SG says we can save the day, we can fix it. And it's going to be more than equitable estoppel, but it isn't going to be that much more. Arm's length, valuable consideration, materially identical claims. I want to know what I'm buying there. What I know how to apply equitable estoppel. What kinds of questions do you think will arise and this court will have to address if we bless this new revised and improved version of assignor estoppel?
Thank you, Justice.
So I have to say, Gorsuch is being the law professor here. Right? He's not being the district judge. He's not being the Supreme Court justice. He's really being the law professor, saying, okay, now tell me what this portends in the way in which this will play out down the road. Because if you take the view that equitable estoppel is still going to exist, and you and I may debate whether that arises from some sort of federal common law. I think that's your view, and my view that it might be 50 different states, depending on where the district court sits and what citations get made to general principles of equitable estoppel in that state. You think it'll be no citations to federal court cases, typically federal patent cases, dealing with equitable estoppel, although I don't know if there's that many cases that deal with equitable estoppel in the federal system.
It doesn't come up that often.
Doesn't come up because it would be called assignor estoppel. It wouldn't even be called equitable estoppel. They'll have to analogize to state court cases, which will typically be the state in which the district judge sits. But putting that to one side, let's listen to the answer that the advocate gives and then question whether he's actually answered the question.
Yes, of course. My view on this is that the most troubling question that you'd be buying is what to do about the disputed meanings of never issued or the disputed understanding of pending applications for patents, pending patent claim terms. Materially identical, again, I mean, if it's given a really robust application by this court and it's made clear that it is, something in the nature of approaching textually identical, well, then you have, I think, a fairly a strong basis for being assured of consistent application. But the risk of inconsistent application, the risk that an inventor never intended something, but is later, with the benefit of hindsight and able lawyering, as attorneys for Hologic are obviously able lawyers, going back and filling in inferences and assertions about what was written down in an application in 1998 should be understood to mean today in light of everything we know today, I think is pernicious. And I don't think we should be getting into that.
Why would equitable estoppel solve that problem?
Because equitable estoppel is focused on actual representations. You need to have an actual representation. What is it? And you also need to have reliance. So because you need both an actual representation and reliance, and we've obviously briefed that we think assignor estoppel 2 requires representation and reliance, but the questions have asked me.
So let me interrupt you there. I'm sorry, just see if I understand the delta here. Most of these cases involve small inventors assigning patents to very large corporations and who are fully capable of examining the patent and maybe in better position to identify its validity, and who undoubtedly very rarely rely on these individuals. And if we get rid of material identical, if we require material identically claims and get rid of reliance, we're really just advantaging the large inventors to the disadvantage of the large purchasers to the disadvantage of the individual inventors.
That's exactly right. I think one of the things that it makes reliance so important is that it ensures that there's a kind of something akin to a meeting of the minds. Everybody knows at the relevant time what they're talking about. And having to figure that out with the benefit of hindsight, here we are almost
blowing away reliance requirement just gives a free pass to the large purchasers.
Exactly.
Thank you.
So what do you think is going on there? Is that Gorsuch saying, I'm trying to understand whether the result here is that big companies have an unfair advantage over small assignors, and that small assignors should be able to challenge their own assignments, whether they're employees or non-employees or contractors or even just individual inventors?
I think he's trying to figure out who's playing who, right? Who's taking advantage. So the story that's been told, right, is small inventors, employees give blank these assignments, and the large inventors, the large companies then take it, expand it all beyond what the inventor even ever intended. And then when the inventor goes somewhere else, they go after him with it.
Right. And interestingly, what I wanted to tie it to for a second is our last podcast, which is the fair use doctrine came in to sort of save the day for Google, which is a large company, which of course Oracle feels enabled a larger monopolization through the fair use doctrine, amplifying the ability to use software that perhaps is protected by at least a thin copyright. And I wondered to myself as I was listening to the argument, how are these competitive issues all being thought of by the court? Because it seems to me part of what's going on is almost a statement that we want less litigation in the federal courts. Fair use might produce less litigation. It might produce more litigation, at least for a period of time. But I wonder whether assignor estoppel will produce, or getting rid of assignor estoppel will produce less litigation in the federal courts or more litigation in the federal courts.
Well, right. Yeah. I don't know if they're looking at it as more or less litigation versus more or less bullying.
More or less bullying, like big companies bullying individual assignors who decide, hey, I'm going to work for a competitor and I'm going to bring all the prior art with me. And hey, if you sue me, I'm going to challenge the validity of the patent based on all the prior art I know. And they say, no, you can't do that because basically we have a contract with you, or we have an oath, or we have, contract and an oath, and maybe a sum of money to boot. And in California, they couldn't get a non-compete, but if they could, they would get that too in some states as well. It's like a battery of doctrine, a battery of contract clauses that would all be set forth in the exit agreement, with maybe some provision for garden leave, where people would be asked, don't do anything that disrupts us in any way, even though you're leaving the company. So there are lots of competitive issues that are sort of wrapped up into the story at the same time here, right?
Oh yeah. I mean, that's definitely.
So what's your view of where this will likely go? You could argue that if people want to stay with stare decisis, which looks like where Justice Sotomayor was, maybe you take the view, just leave things as they are and let Congress decide, right?
Yeah, I think they say that they leave it where it is. There should be some estoppel, but it's not boundless. And then maybe they'll figure out this one reaches the limit and maybe give a little bit of guidance about the future, or maybe not. And then let the lower courts figure out where the bounds are.
So you're saying this case is really not going to do major deletion of an existing doctrine that has sort of stood.
If I had to predict, it would not.
It would not.
It would not. I think it'd be the same as Lear v. Adkins, where they'd say, well, there's inroads against it, but it's a long time stare decisis. There's no reason to get rid of it, but maybe there are some limits to it. But in this case, may or may not reach that limit.
I mean, what would you do, just to end on this practical note, what would you do if you were drafting a contract right now to acquire a patent from an individual inventor knowing that this case is out there? What would you do? Like, how would you handle it?
I'd get a specific representation. But
you would write it.
Right, because, I mean, licensee estoppel, right? The Lear v. Adkins says that such a representation is void. But there's nothing, if they get rid of assignor estoppel, that doesn't mean that any representation saying that I won't challenge the validity is void, right?
Well, I think what you're hinting at is you would try to come within what they seem to be recognizing is still a live doctrine, which is equitable estoppel. And you would say, we are relying on your representation of X, Y, and Z and paying you the amount we're paying you. And if you...
I'd go more than equitable. I'd rely on that, but I'd make it more explicit, right? I promise not to challenge in the future. I promise not to be involved in assisting any challenge in the future.
Right, but if you package that all together, you could be setting up something where if the court goes against you, you've got kind of an invalid contract there, right?
Well, that's what I'm saying. Why? Just because you get rid of assignor estoppel, right? This is not Lear v. Adkins. The court, even if they get rid of assignor estoppel, is not ruling that such representation is void. They'd have to make new law to do that.
Right. So you're saying you would do drafting in a way that was even more aggressive towards the...
Yeah, you make it separate paragraphs and you put a severability clause in.
Right. And I guess if you really wanted to spell it out, you would say there's a refund, like almost a right of decision.
If you challenge at your own risk, we want our money back.
Right. You'd almost set up something now.
Right. Because you don't even need to have a challenge. If this is found invalid, we get our money back.
Right. So at some point then, if you're
that'd be putting your money where your mouth is.
But if you're representing the assignor often wants to do an as-is transfer, right? They want to do something that sort of says...
Yeah, because they know if whatever they're assigning is garbage, right?
Well, they don't know. See, that's...
they don't know. I'm just kidding. Right? They don't know. Of course they don't know. You never know.
See, that's the problem with patents. You really can't say, well, it's like a piece of land. There's a recording system. There's meets and...
Right, you can't warrant.
Surveys.
Yeah.
I mean, there's enough in the deed that there is an estoppel against the seller of the real estate.
But you could say, if this is invalidated, you could have liquidated damages. If this is invalidated because you breached this, you pay us $1 million because that's what we think this patent is worth.
Oh, even more than what the actual amount was that was transferred?
Yeah, why does it have to be just a refund, right? If the patent is going to be worth a lot of money down the road and you help invalidate it, that's going to hurt us.
Well, under your view, we'd eventually have some federal body of law dealing with what's appropriate liquidated damages, right? Because you would say, in the context of patents, contracts, you're writing.
No, that might be state. Whether the value of the foregone patent,
right?
That might be state.
Well, I think state law. This is what confuses some of it because they want a uniform federal policy. They want a uniform approach with no forum shopping throughout the districts. They want the federal circuit to get it right. And the federal circuit has been of the view that assignor estoppel is valid, that assignors can be estopped, period, full stop.
Right.
And so they want to do something, and they step into areas that I think they ultimately may regret. And this might be a case that they step into that they end up regretting, because it's a little bit like Alice, in the area of whether or not computer software is or isn't patentable. They may end up regretting what they've done in that case. I don't know what you think. We've touched on this at the end of our last.
I don't think they mind that much.
They don't mind that.
They haven't taken another case to like limit it. We'll see what happens with American Axle.
Right. Did they take it or it's still pending?
I think it's still pending.
Anyway, maybe we can revisit that case and take a look at what the pattern of these cases has been this term. I tend to think that part of the pattern is a sense that the federal district courts, as well as the federal appellate courts, are overwhelmed. So if they can do things that somehow keep cases out of court, like copyright fair use might do in the Oracle versus Google case, or maybe the way they handle the assignor estoppel doctrine to keep cases out of the federal courts is something that they want to promote. But maybe you'd say, no, they're thinking a different way here.
Yeah, I don't think they're thinking about that.
Okay. Well, thank you, Professor Michael Risch. You're always entertaining to be with. I appreciate you spending some time on this. We'll see how it's...
No problem. It's my pleasure.
Yeah, you're the best, man. Talk to you later.
Talk to you later on. Bye-bye.
Bye.
Tune in next time on The Valley Current.